Hope you had fun. For those of you that play video games, I recently purchased, what was it? Dragon Quest 11S for the Switch. I'm still trying to figure out whether or not I like it. Part of me wonders if I just would have done better to just beat the games that I already had. So, like, circled back to Fire Emblem Three Houses or anything else. But let's get back into the work in terms of technological advances. I may or may not shift over to Zoom, break down and make a Woo buy me a license for the rest of April. And then if that actually happens, first of all, I'll let you know. And second, what would that mean would be that the actual live engagement of my class would happen on Zoom, and then the recap, well, not the recap, the actual video footage of the lecture would be on YouTube. So for you all, it wouldn't be much different than the experience is now. But the rest of the plan is to finish up today the rest of the courts section. The game plan would be Wednesday and Friday would be dedicated to elections and parties and interest groups. I'm trying to make sure that we have enough time left to do. Let's see how many more sections we have to do before the end of the semester. I think we're actually en route to be on time. Yeah, because this is the courts that I'm finishing up, and then elections, then parties and interest groups, and then American public policy. Yeah, we're actually on track to finish. Huzzah, right? So let's get back into it. So when we left off, I was getting ready to talk about the power of judicial review. And basically all judicial review is just the ability the courts have to declare actions of the legislative and executive branches valid or unconstitutional. It's like, nope, you can't do that. That's all judicial review is. Believe it or not, judicial review was not a feature of the court system when the court system was created. Judicial review did not exist until it was asserted by the court in the case of Marbury versus Madison back in 1803. And basically, in that case, William Marbury had been granted a judicial commission, but the commission had not been delivered in time. As a result, Marbury sued, and the court ruled that the portion of the Judiciary Act of 1789 actually gave the court the power to compel Madison to deliver the commission was invalid. And so as a result, the court had asserted that the power to rule had as a result, the court had asserted that it itself had the power to determine whether or not a law would be unconstitutional. And so, really, the power of judicial review was a seldomly used ability, a seldomly used power. However, in the last couple of decades, or at least as long as I've been alive, the power has been used frequently. Most recently, the power has been used to reverse state actions, overturn federal agency actions, challenge presidential action, and then, of course, overturn federal law. Generally, Supreme Court decisions are honored by the other branches as well as by the states, in part because not Congress, the court is aware of the danger to its institutional reputation if a decision is ignored. So the court is not reckless in issuing opinions that challenge other institutions. But there have been a few times where other branches of government actually ignored Supreme Court rulings. One such incident involved the so-called Cherokee cases. This is actually back in my home state of Georgia, where the Supreme Court actually ordered the return of Cherokee lands taken from them by the state of Georgia, and Georgia never returned those lands. Other instances of it immediately after Brown v. Board. I think I talked about it briefly. Actually, we were supposed to talk about it, and I think we never got around to talking about it. But during the civil liberties section, talking about like integration and all that stuff. The first case, of course, we all know about Brown v. Board that determined that separate but equal, especially as it pertains to educational spaces, is unconstitutional. But there was a second ruling of Brown v. Board 2 that actually the Supreme Court tried to sit down and actually design exactly how this integration process was going to take place. And they ruled, they gave the phrase with all deliberate speed. And ever so often, especially I want to say in the last 10 years, you would hear about these documentaries being done in bumblefuck rural deep south. I know there was a big one when I was in high school that was talking about some rural part of Georgia that had separate proms as well as I wanted to say separate high school graduations. And it was like this huge thing because the kids all wanted to party together, but they couldn't because it was like it was still a school practice that was a artifact from trying to maintain segregation in relation to with all deliberate speed and in response to Brown v. Board decisions. I'm trying to think of other instances where people choose to not adhere or totally choose to disregard Supreme Court rulings. Outside of those two, it's really rare. It's really, really rare. I mean, because if a governmental entity, so whether local, state, or national, chooses to disregard a Supreme Court ruling, I mean, it's the implications of it are huge. And so what could end up happening instead is instead of like protesting, you may file another appeal, or you may just bide your time, adhere to the court's rulings, and then wait and bide your time and see if you can find another opportunity to challenge said issue in the case. So of course, I think it's not I think. Eventually, I think I've heard conversations that the conservative aspects of the Supreme Court, of the Roberts Court, is waiting for an ideal case to come up that would ultimately ban abortion. Really can't ban abortion right now. Roe v. Wade makes it legal. There has not been there has not been a case that has risen up through the ranks that is interesting enough for the court to hear the case to actually challenge it. And so as a result, people have to adhere and to a certain extent provide access to abortions, to termination of pregnancies. Unless, of course, you're a state legislature and you've managed to get bills passed that actually limits that access. And doing so does not directly, it does not directly disregard the Supreme Court ruling. It's totally different. This goes into how are states able to do this? It's as a result of the 10th Amendment. I've been rambling. My bad, y'all. So let's actually talk about how many Supreme Court cases actually invalidated rules of Congress. So yeah, since I've been alive, it's been happening far more often. So 90s baby. So between 1985 and 2014, 58 cases. There have been 58 acts of Congress that the Supreme Court has later determined to be unconstitutional or invalid. Also between 1955 and 1984, 52. It is, I would be willing to argue that between 1895 and 1924, and then again between 55 and 84, and then 85 through the present day, the reason why we see these large numbers of of Supreme Court rulings invalidating acts of Congress is because it's during these times that we see a lot of change in America. In particular, that 1895 to 1924, you have the tail end of Reconstruction, when slaves were freed, black men could vote, moving around, trying to not ascertain, but get a piece of that American pie that they had long been longing for. And then, of course, World War One, and then the Great Depression. So, and with FDR like working really hard to try and redefine as well as reboot the country. That's why you have so many cases during that first time. Between 55 and 84, you have the beginning of the classical phase of the civil rights movement. What do you mean by classical phase? Well, if I recall correctly, that was 1955. The Brown v. Board case was decided. We also have that. You have the civil rights, Martin Luther King, Rosa Parks, uh, the bus boycotts, the March on Washington. You have Vietnam protests. You have what is it? Third wave? Is it third wave feminism or second wave feminism? The burning of the bras. That still happened during this time here between 55 and 84. Let's see. Kennedy was shot. So many things happened between 55 and 84. So yeah, during this time, America started to transition and transform into what we've now come to understand as being modern America. And then between 85 and 2014, still growing pains and changes, really redefining exactly what the government can and cannot do, especially if we look at what happened in between '01 and '04, immediately after 9/11, and changing exactly what the government can and cannot do to its people in terms of surveillance and what access does the government have to certain things. Makes perfect sense. So let's talk about the Supreme Court in action, in particular, rules of access. The Constitution defines judicial power as extending to cases and controversies. This means no advisory opinions. Parties must have standing, and standing refers to the right of an individual or an organization to initiate a case. And then the issue must not be moot, basically, a case that no longer requires resolution. So, whether or not a case is moot is certainly open to interpretation, and this gives appellate courts considerable power to control the agenda. One argument made in effort to keep Roe v. Wade off the Supreme Court's agenda was that the pregnancy in question had already come to term. As such, the case was moot. However, the court originally rejected that argument on the grounds that such a timeline would preclude any consideration of a similar case. Likewise, the question the Supreme Court examined in Roe v. Wade was not about the pregnancy per se, but the right to privacy. Okay, so basically, what was going on back in that case, back in 1969, 21-year-old, last name McCorvey, discovered she was pregnant with her third child. She went back to Texas, where her friends advised her to falsely assert she had been raped in order to get a legal abortion, with the incorrect assumption that Texas allowed abortions in case of incest and rape. The scheme also would fail because there was no police report documenting said alleged rape. Regardless, the Texas statute only allowed abortion for the purpose of saving the life of the mother. She attempted to obtain an illegal abortion, but found out that the unauthorized facility had been closed by police. Eventually, she was referred to the attorneys Linda Coffey and Sarah Weddington. McCorvey would end up giving birth before the case was decided, and that child was ultimately put up for adoption. In 1970, the lawyers filed suit with the U.S. Court in the North District of Texas, on the behalf of McCorvey. The defendant in the case was the Dallas County District Attorney, who represented the state of Texas. McCorvey was no longer pregnant, but was no longer claiming her pregnancy was the result of a rape, and later acknowledged she had lied about being raped. Rape is not mentioned in the judicial opinions of the case. And then in 1970, the panel decided that the Texas law was unconstitutional, finding that it violated the right to privacy found in the Ninth Amendment. In addition, the court relied on the some justices' 1965 concurrence. Regardless, the court decided to decline to grant an injunction against the enforcement of the law. Yeah. So basically, in this case and in others, when we're talking about moot, uh, courts really would prefer not to deal with cases that it's already been resolved. So another example that's more recent is Fisher versus UCLA. I think that's the proper name, or is it USC? Abigail. Why are we doing this today, computer? Abigail Fisher. Okay, yeah, not USC. It's Fisher versus the University of Texas. I remember this case from, oh wow, we had two of them. Didn't know there were two cases. All right. So there were two cases. Anyways, this happened back when I was in school. What year was this? Yep. So this happened back when I was applying for colleges. This was the case concerning the affirmative actions policy that happened at the University of Texas. Abigail Fisher was applying for schools. As you all know, not recent, freshmen, sophomores, heck, even seniors, you know how stressful it is that your resume has to be up to point and all that. And then there are certain state schools, certain public schools that have X amount of seats set aside for the valedictorian and salutatorian, and like essentially the top 1 to 2% of the high school graduating class. Well, but not unfortunately, University of Texas also had seats designated for their diversity and inclusion in relation to an affirmative action policy that they had set aside for these seats. Abigail Fisher was not smart, was not talented, did not have anything stellar about her resume. She was just your average student, just average, plain Jane. She really wanted to go to the university, she wanted to go to Texas. However, she did not get in. And she argued, or her parents and then later the lawyers argued, that as a result of the school's affirmative action policies, she was not accepted. So they prioritized minority students of color or from diverse backgrounds that had similar, if not worse, packages than she did. And this case was ultimately ruled, heard, and determined. Yeah, the original case came out in 2013. If I recall correctly, Abigail Fisher ended up going to, what school did she end up going to? Yeah, she went to LSU. She ended up going to Louisiana State University and graduated with a degree in finance. However, the reason why the case continued onward because it became a question of what's it call it? Should we continue to have affirmative action policies? And if so, under what cases? Ultimately, the courts ruled against Fisher because they argued like this case should have never gone up this high. She really didn't have a valid case. Go back. Da, 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 da. So this graph just shows the number of cases filed with the Supreme Court. As I said on Friday, the number of cases that the Supreme Court hears every year is less than 90. We see in 2015 there were almost 9,000 cases. 9,000 cases in 2015. Uh, Let's see, upcoming cases or cases that have been heard or will continue to be heard eventually. We haven't heard whether or not they've been heard yet. We have Bucklew versus Precythe. This is the case in which the court will decide if the evidentiary burden of an inmate raising as an applied challenge to the state's method of execution and receiving an alternative execution method. So in this case, the inmate argues that the state's preferred choice of execution is it cruel and unusual. I think he's allergic to. He has some type of health condition that the lethal injection would actually cause far more harm and a torturous death. And so I think in that case, he's actually requesting the what's it? I can't even remember what it's called when you get shot. When you get shot, shooting squad. Oh, yeah, shooting squad. Then we have Gamble versus the U.S. That is the case in which the court will decide whether to overrule separate sovereigns, exception to the double jeopardy clause, particularly if the federal government can try and punish a person for a crime he was already tried and punished for at the state level. So Gamble, in particular, was tried and found guilty for robbing a bank, if I recall correctly. He was, of course, he was arrested in received charges at both the federal and the state level. What ended up happening is the state level had already had its court proceedings and already sentenced him, etc. And then it was time for the federal side. And he's arguing, well, hold up. Double jeopardy says you can't be tried for the same crime twice. What he's arguing is because he was already tried at the state level, he shouldn't be tried at the federal level. Even though, when we think about double jeopardy, we're usually talking about being tried for the same crime, parentheses, at the same level. All those movies that we see on Lifetime and all that stuff always show the woman, killing the evil ex-husband once she discovered that she was falsely imprisoned and then falsely found guilty for murdering a person that's already alive. Then she kills him. Then she can't be brought up on murder charges because she's already been tried and found guilty and served her time for killing the husband and killing the man in question. And so that's our traditional understanding of of double jeopardy. But in this case, it's I've been punished at the state level, therefore I should not have to be punished again at the federal level. But it's like, ultimately that case will cause us to question exactly our understandings of dual citizenship, as we're bringing this into double jeopardy. Another case, Madison versus Alabama. In this case, the court will ultimately decide whether the Eighth Amendment that prohibits, cruel and unusual punishment will prevent Alabama from from executing an inmate whose mental disability renders him unable to remember the crime he is to be put to death for, much less understand the circumstances for his execution. So, is it cruel to put a man to death who no longer understands why he is in jail and why he has to be put to death, why he has to be killed? Is that cruel and unusual punishment? And the reason why he no longer remembers is because of a mental situation or a health situation. Interesting question, right? And then yeah, that's it. So stay tuned. So more about access. Beyond those original rules, those original three rules being no advisory opinions, parties must have standing, and the issue must not be moot. The court chooses to hear cases based on the preferences and priorities of the justices. The justices' clerks pore over all petitions and generate memos on the various cases, and any one justice can ask that a case be considered for a hearing. The nine justices meet to determine which cases will be granted a certiorari. For those of you who are interested in going to law school and stuff, of course, becoming a federal judge clerk or a Supreme Court justice clerk is one of the coolest clerkship gigs you can get. And if you secure one, your life is. Actually, I know someone that I went to college with, undergrad with, that managed to procure a federal judge clerkship, and he now works for the solicitor general. So, like, I too know people in high places. Anyways, so what is this certiorari? Butchering all the words today, y'all. A writ of certiorari is a formal request made by an appellate to have the Supreme Court review a decision of the lower federal courts or state courts. A certiorari is granted when there are conflicting decisions by two or more of the lower courts, as well as when there are conflicts between a lower court decision and a previous Supreme Court decision. So, in one case, if there is incongruency, let's say we're going to state level, between the trial and appellate court, or between the appellate court and the Supreme Court, the state Supreme Court, that's what I'm referring to, the state Supreme Court, or between, on the federal side, between the lower level district court and then the U.S. Court of Appeals. Or if the decision reached at the, say, state Supreme Court level or the appeal court, or even at the U.S. Court of Appeals, directly challenges a previous, Supreme Court precedent. If there's any type of incongruency, that's when the Supreme Court steps in. And so an example of this happened back during the Obamacare not working, drafting and all that hoopla. Let's see, the Supreme Court decided to hear the case related to Obamacare because there were important questions of interstate commerce and federal power, and in which the lower court and appellate courts differed. You know, that whole option of whether or not states had to be forced to expand their Medicaid roles. And of course, you can't force states to do that. So, how many of the 9 justices must agree in order to grant a writ of certiorari? Is it 1, 4, 5, or 9? Toss a coin to your witcher, O Valley of Plenty. The answer is B, 4. The rule of 4 is only mentioned briefly by Lowy et al., but it's a great way to explain not explain, it demonstrates how Supreme Court justices behave as rational actors. They seek, in order to seek to pursue their own policy ends. A minority of the court can require the entire court to hear a case. But justices have to think carefully about how the majority of the court is likely to receive particular cases. It's easy to set one's own cause back by forcing the court to hear a case only to have the outcome be different than what the minority had hoped. Because the doctrine of stare decisis, it's not likely that the same justices will get another chance to rehear a case related to their own policies of interest or issues of interest anytime soon. So, of course, while I talked about previously that Kavanaugh and other conservative voices on the Supreme Court are looking for their perfect opportunity to hear a case about, as it relates to abortion rights and access, they are not just going to pick any old case, and they're not just going to try to force the rest of the court to hear a case on it just to have the decision set back their cause another million years or another million steps. They have to wait for the perfect one. They have to pick and choose and abide their time, like the Manny Fresh gift rubbing hands. You got to do it right. Otherwise, what's the point in doing it? And so this graph describes exactly how one reaches the Supreme Court through certiorari. So let's zoom it in. Da, 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 da. All right. So on the state side, you have your trial courts, and then you have your state trial courts, also then known as superior or circuit courts. Then you go up through the intermediate appellate courts. Then you have your state Supreme Court. Sometimes you could just leave the intermediate and jump straight up to the Supreme Court, especially if you're in one of those 10 states that doesn't have it, the middle layer between state court and that. Yeah. Then you get your discretionary review, and then if they say yes, then hooray! The Roberts Court will hear your case. Meanwhile, on this side here, you have your federal agencies that can write and send in requests to the Court of Appeals. Or first, you start instead here. You go to the district courts and they decide on issues of law and fact. Then you go to your appeals. Then you go here, and then if they think your case is worthwhile, hooray! That's how you get to the Supreme Court. Gosh, they really out there doing laundry, huh? Not laundry. Lawn work, landscaping. Ooh, it's early, y'all. So, what else controls the flow of cases? You have your Solicitor General. Elena Kagan. Kagan was one of those. Justice Kagan was a Solicitor General. Basically, the Solicitor General, which is an officer in the Justice Department, screens out many cases in which the federal government is a party. Likewise, law clerks. Each justice has 4 clerks, and they're drawn from the top law schools across the nation. And these individuals also screen cases for the justices and then assist in general legal research. As I said not too long ago, being a law clerk is a cool gig. It's a great gig. It's a really great gig. And it's also really, really hard to get. Because actually, I don't know how long you serve as a clerk. The reason why I don't know this is because I didn't go to law school. And I was only pre-law for like a month, sophomore year. So let's talk about what happens once you make it to the Supreme Court. So your case is made it. So what happens is that the parties to the case file briefs. Briefs are just documents in which the attorneys explain why the court should rule in their favor, why he or she, their side is right. Amicus curiae briefs are briefs that are filed by those who are interested in the case but not a party to it. Amicus curiae means friend of the court. After the briefs are filed, then you have your boxers. No. Oral arguments come next. During this time, the attorneys actually appear before the court, present their arguments, and then answer questions from the justices. During the time that they are presenting their arguments, they also answer questions, and then in some ways, while they're presenting their cases, they can be peppered. They could be attacked with questions right and left, and it depends. Some people wonder if the more questions the justices have during the brief in question, not during the brief, during the oral arguments, is that indicative of their interest in the case? Not only their interest, but with the more questions, trying to determine whether or not your side is actually the more valid side or the valid argument. We'll find out. Okay, so oral arguments have ended. Then what ends up happening is conference time. Woo! What happens during conference time is that the case is discussed and then a preliminary vote is taken. Then the opinion writing happens. During the opinion writing, one of the members of the majority is assigned the task of writing the majority opinion. Drafts of said opinion are circulated and then changes may be suggested. Justices who were in the minority may write one or more dissents. Let's see. What ends up happening is that sometimes you can have two dissenting ones, minority opinions, where some justices could feel that they disagree based on A, B, and C, when another justice could actually disagree because it's only G, H, and I. Or you could even have a concurring opinion where it's like, I agree, but the reason I agree is slightly different than the majority opinion. And so this is the entirety of the Supreme Court's decision-making process. You get your petitions, then you make it to the semifinalist pool, the Certiorari pool, then you can make it to the discuss list. Then there's conference time, and during conference, you have your briefs and your amicus curiae briefs. Then you have your oral arguments, and then there's another conference where we sit down and say, okay, and of course, during the conference time, the Chief Justice leads it. He is the first person to speak and the last person to vote. And then, everyone drafts up their opinions and dissents. And then we all wait at the beginning of the summer to find out what were the rulings for all the cases for the last session of the Supreme Court. And then everyone goes on about their day. Apologies, y'all. I really hate that they decided to start cutting the grass outside of my house today. So, when we're thinking about decision making in the court system, we have these two philosophies or these two styles of judging, for lack of a better term. We have restraint and activism. Judicial restraint refers to judges who refuse to go beyond the text of the Constitution in interpreting its meaning. So, what does the Constitution say? What does it say? What do we understand it to say? That's it. Meanwhile, activists, on the other hand, argue that the Constitution is a living, breathing document and that, what was written and meant back in 1789 should not be as influential or has as much say and control as what happens in 2020. That not George Washington, Thomas Jefferson, the Adams et al. Could not fathom the society that we live in today. And as such, you have to be realistic and you have to be modern and you have to acknowledge change when it happens. And so as a result, that the court should see beyond the text of the Constitution or what as well or a statute or any other law to consider the broader societal implications for its decisions. Like if we continue to believe and follow everything to the letter of the Constitution, we would still only count citizenship for, of people of color, in particular Black people, 3/5. 3 out of 5 every, 3 of every 5 Black people is considered what, one white person. If we continued with that, because that's in the Constitution, but we don't adhere to that anymore either. We have amendments added on to that. I mean, the fact that we add additional amendments demonstrates, in terms of if you look at it from the activist side, that it's a living, breathing document and things change. Things change all the time. And so, not even depending, actually, now let me get to the second part so I can do this properly. Political ideology. What about that? You can be a liberal or a conservative. The extent of liberal or conservative ideals and attitudes of justices also play an important role in their decisions. This is what I was going to say. Activism and restraint are not synonymous with liberal and conservative. You can be a liberal restraint. Like you can think that all of these, you can think that all of these processes and all of these social programs, etc., should exist, but be restrained. So while you can believe, and it'd be hard as hell to actually make it happen, or you could actually argue that the only way it could be, make it happen is you truly believe in the 10th Amendment, the 9th and 10th Amendments, that rights that are not articulated belong to the states or to the people. And so as a result, the way that the government actually, citizens would actually go about getting, their UBI, if you will, universal basic income, would be to fight for it through the state governments as a result of, being a restraint. Or you could be conservative and be a judicial activist. If we use the example that I've used throughout this lecture talking about abortion access and abortion rights, you could say that, well, initially the forefathers did not imagine that women would, would become equal players in politics as well as society. And as a result of all of this, that allowing access to abortions really, marginalizes and oppresses families as well as unborn babies who also should have rights and access to not people, but protections and stuff. And so as a result, you could be looking for opportunities, and not even opportunities. Your rationale for certain cases would be looking at the societal implications. Like, there's nothing in the Constitution about abortion. Well, because at that time, the founders did not think that would be a thing. Women were still more or less not similar to slaves in terms of property, but they weren't equal citizens. And now they are. And so now we have this question. And so as a result, we as justices, under that whole activism ideal, we have to look at this differently. And so let's talk about the expanding power of the judiciary, our last slide. During the 60s and 70s, the courts liberalized standing. In doing so, that means more people could sue and more entities could sue. The courts also broadened the scope of relief by allowing for class action lawsuits. So like those commercials you see during daytime, especially now that we're home, the ones that I see now are the Roundup commercials where, what was it? Suing Monsanto because they found out that Roundup, long-term use of Roundup causes cancer. So it's like, if you or someone you know used Roundup weed killer and has developed cancer, please call. I can't even remember the names of the law firms that are on TV that do it, but you can call one of those for class action lawsuits. I think I received $20 from a class action lawsuit not too long ago. I don't know. I don't know what it was for, but I do remember getting those $20 like right before spring break. I spent it on Pokeballs, probably. No regrets. Let's see. Also, as a result, the courts began employing structural remedies, sometimes retaining control of a case until a mandate was implemented. And so all three of these things, liberalizing standing, allowing for class action lawsuits, And then retaining control of a case. These are all expansions of judicial power. It's also important to note that one additional way the courts maintain its power is by wrapping the courts and its justices in a mantle of mystique, from the robes to the marble surroundings to the way that the justices are introduced by the marshal of the court. The mystique of the Supreme Court adds to the credibility of its decisions. It makes the justices look way more impartial, and the court to look more apolitical, so less political, make it appear to be less of a political institution than what it is. And so I don't know if any of you ever did one of those cliche trips to DC when you were in high school. I did. And I remember when we actually went to the Supreme Court building and going on the inside. First off, it was really lucky. It was one of the times we could actually go in and see the lobby. And I remember seeing those red drapes and like trying to peek in and trying to see what it looked like. It did look really sketch. All you see these red robes and you see like them sitting up here like where they're supposed to on this bench and like they sit high up. It's really sketch. And that was almost 15 years ago, Lord. But like you don't like and you can't take pictures on the inside. There's no pictures. They have like those fancy artists that draw they draw depictions of actually what happened. They don't allow cameras in there. It's really weird. Yeah. So this is the end of the court system. As I stated in the previous video and all those other ones, unhappy with your midterm grade and you made less than a 75, continue to take those reading quizzes. They are available for you. Take them. Each one that you take between now and the end of the semester, 1 point towards your midterm grade for a maximum of 9 points. On Wednesday, we will continue with elections. This is a shame because, well, not a shame. Hopefully by that time I should have some attack ads. Just because we're all sitting at home trying to fight the coronavirus doesn't mean politics isn't happening. Y'all enjoy the rest of your day.